While we commend the efforts of government, and in particular the Minister of Information, for the leadership shown regarding the repeal of the criminal libel law, Legal Link is however perturbed and gravely concerned with the plethora of issues enshrined in the proposed Cybercrime Bill that is currently before the House of Parliament for enactment. Our legal team, superintended by the human rights expert and former Commissioner for Human Rights, Dr. Rashid Dumbuya, have been able to do a critical examination of the proposed Cybercrime Bill. Concern number 1. The Cybercrime Bill transforms the Minister of Information and Communications into a demigod and chief judge of the state. By Section 25(1) of the bill, for example, the minister is given powers to prescribe punishments that should be meted out on convicted persons under the bill by way of regulations. This is overtly ridiculous. Extending judicial functions to an executive authority is not only dangerous, but anathematic to the principles of separation of powers, rule of law, and democratic good governance within the state. Sentencing of convicted persons is an exclusive reserved work of the judiciary, enforced by magistrates and judges in accordance with the law or sentencing guidelines. The Minister of Information and Communication is deprived of this legal expertise and acumen. It's important to also emphasize that the Minister of Information is a politician, and without powers of punishment at his disposal, he might use it with his affection to silence opposition politicians, journalists, interest bodies, and civil rights activists who may be critical about the excesses of government to which he is a stakeholder. The Act must prescribe clear punishments that will be meted out to anyone who contravenes the provisions of the Cybercrime law. The power to determine punishment for offenders of the Cybercrime law must be taken away from the minister. In a democratic society, it is suicidal to place such powers in his hands. Excessive and unlimited powers given to the police or other unauthorized persons regarding search and seizure of stored computer data. Like the Minister of Information and Communications, the police also enjoy unlimited and excessive powers under this bill. Under Section 5 of the said bill, the police or other unauthorized person is given unrestrained powers to institute search and seizure of computer system, program, data, computer data storage materials through an order of a judge of the High Court for purpose of serving as evidence in a criminal investigation or proceedings. Once the police or other unauthorized person has been able to secure this order from the court, he will now have the powers to compel any person or entity to produce certain document, data, or information, be it confidential or not. This version of the bill has the potential to undermine the right to privacy, which often characterizes certain professional people, like medical doctors, lawyers, and journalists, compelling them to produce documents that ought to have remained confidential. This is clearly a lacuna that will definitely create room for endless human rights violations of the individual privacy rights of citizens. The proposed bill must make it mandatory for an order of the court to be sought first before a search warrant and seizure be extended to third parties. Also, exceptions should be given to safeguard confidentiality information, data, or agreements being seized at will by police officers. The bill does not define who an authorized person is. While the proposed Cybercrime Bill gives many powers to an unauthorized person in the area of search and seizure, it is interesting to note, however, that an authorized person is not defined under the bill. This omission leaves room for speculations as to who this authorized person will be. Not defining who an authorized person is under the bill is a grave omission and must be rectified forthwith so as to avoid abuse of authority by the state. The proposed Cybercrime Bill contains offenses with no accompanying penalties and sanctions. The drafters fail to explicitly prescribe penalties for the many criminal offenses that are mentioned under the Act. It is best practice under legislative drafting for legislations that create offenses to equally provide for sanctions and punishments in the event of any breach. This is to ensure that convicted persons are not overpunished or underpunished. The bill must expressly set out clear-cut sanctions for any offense committed under the Act. Sanctions must not be determined after the commission of the offense. They must be certain and foreseeable. The scope of the Cybercrime Bill extends beyond natural persons. According to the bill, the word person, in quotes, is defined to include, among other things, a natural person, a corporation, a company, a partnership, a firm, an association, or societies. This shows that political parties, civil rights organizations, media houses, and other interest bodies are not exempt from liability under this act. In a democracy where political parties, CSOs, media practitioners play a leading role in holding government accountable, serving as watchdogs and raising awareness on its cases, this may be quite worrying indeed. With such provisions, the Cybercrime Bill may be used as a weapon by the ruling government to suppress opposition parties, journalists, CSOs that are critical of its policies and programs. There is need for the scope of the bill to be narrowed down to individual persons. Where it is necessary for the bill to have jurisdiction on corporations, companies, partnerships, firms, associations, clear-cut guidelines must be stated under the bill to protect political parties, CSOs, media houses from being suppressed and invaded illegally. The bill also sets out to invade into the private rights and activities of diasporans. Under Section 13 and 14 of the proposed bill, for example, the Attorney General and Minister of Justice of the Republic of Sierra Leone is empowered to request from a foreign state assistance that is aimed at investigating or prosecuting offences under this act. With such provisions under the bill, it is certain that the activities of diasporans are no longer immune from invasion by the government of Sierra Leone. Dissenting voices and groups in the diaspora who may be critical of government policies and programs will be of serious target under this bill. The bill must ensure adequate safeguards for dissenting opinions and critical voices residing in the diaspora to prevent a violation of their civil rights and liberties. The Cybercrime Bill makes room for foreign interference, breach of security, public interest, and territorial sovereignty of Sierra Leone. As Section 18 of the bill, a foreign state may request or obtain the expeditious preservation of data stored by means of a computer system located within Sierra Leone, in respect of which it intends to submit a request for mutual assistance for the search, access, seizure, security, or disclosure of the data. This foreign request from a foreign state may likely prejudice public and security interests as well as the territorial sovereignty of Sierra Leone. The bill must ensure adequate safeguards in order for the public and security interests as well as the sovereignty of the state not to be undermined by rogue regimes abroad over the provision of grants and donor funds given in exchange for such vital information or persons. The proposed bill abrogates the rules of evidence in a criminal trial. More negative still, the Cybercrime Bill under Section 4 deems all evidence admissible and further shifts the burden of proof to the accused person to show why the evidence tendered against him in court is inadmissible. Section 4 of the said bill reads thus, quote, "In a trial of an offence under any law, the fact that evidence has been generated, transmitted, or seized from or identified in a search of a computer system shall not of itself prevent that evidence from being presented, relied upon, or admitted." End of quote. The above section clearly abrogates the rules of evidence in a criminal trial. It is settled law that in a criminal trial, the burden of proof rests with the prosecution. It may only shift in exceptional circumstances. Secondly, not all evidence is admissible in a criminal trial, but this seems not to be the case under this new law. By Section 4 of the Cybercrime Bill, it appears that all evidence generated, transmitted, or seized will be deemed admissible in the court of law. The Act must conform to the rules of evidence applicable in criminal proceedings. It is strict law that not all evidence is admissible in a criminal trial. The proposed bill empowers the police or any authorized person for trans-border access to stored computer data without authorization. Under Section 21 of the proposed bill, the police can access without authorization publicly available stored computer data, regardless of where the data is located geographically. Empowering the police or any authorized person to have access to data of private citizens everywhere in the world and without authorization from them may amount to violation of their privacy rights and civil liberties. Recommendation: access to and use of public or private data of citizens by the state must be subject to due authorization and consent from such citizens. This is quite scary indeed, especially for citizens living abroad. And this is very serious. Answer number 10. The composition of the National Cybersecurity Advisory Council invites undue political interference into the action of the Act. Clearly lays a solid foundation for undue political influence, manipulation, and control. Listed below are the members that comprise the National Cybersecurity Advisory Council: the President, the Minister of Finance, the Attorney General and Minister of Justice, the Minister of Internal Affairs, the Minister of Foreign Affairs, International Cooperation, the National Security Coordinator of ONS, the Director General of Intelligence and Security Unit, the Chief of Defense Staff of the Armed Forces of Sierra Leone, the IGO, the Director General of National Telecommunication Commission, the Bank Governor, the National Cyber Security Coordinator, the Director of Communications of the Ministry of Information and Communication, and the Minister of Information and Communication as Secretary. It is interesting to note that all of the above Cyber Security Advisory Council members are key political appointees that are largely answerable to and under the influence and control of the President of the Republic of Sierra Leone. With such kind of makeup, it is obvious that politics will loom large in the oversight, implementation, and development of national cybersecurity legal frameworks in Sierra Leone. The question remains, why did the composition of the Cybersecurity Council not include non-political actors, such as members from the Sierra Leone Association of Journalists, civil society organizations, the Sierra Leone Bar Association, Independent Media Commission, etc.? The reason is simple. The proposed cybercrime law is another trojan horse and political tool designed to suppress political dissent as well as opposing voices both at home and abroad that are critical of the ruling government. The composition of the council shows clearly that the Cybercrime Bill is an apt replacement of the repeal criminal libel law in fundamental terms. The composition of the proposed National Cyber Security Advisory Council must be reduced to 7 members, and these members must include representatives from civil society, the media, interest groups, women, and persons with disabilities. Inclusion of CSOs and interest groups is critical to striking a balance between upholding fundamental human rights and freedoms of citizens as well as regulating cyberbullying, trafficking in persons, and terrorism financing in the cyberspace. So let me just summarize this 10. I think this is one of the fewest of legislations in the world where we have a sitting president as a member of the legislation. It speaks volumes. Most times you don't have a law where the president, you don't see the president in laws as part of the council. The highest you can see is the vice president. So the question remains, where our president should be part of this law?